Good afternoon, everybody. It's so good to be back after a limited COVID experience for most of the month of July. Not a fun thing to have. And I got my injections. I got my vaccine several months ago, so goes to show you. But the doctor said if I didn't have my vaccines, it could have been a lot worse. It was a minor case, so to all my friends out there, please, please, please get your vaccinations. So welcome back. Today we have two fantastic guests that I want to introduce you to. But first, I want to give you the concept of 62 Who Knew for those of you that may be new to joining us. It is actually a look at the double-edged sword, or even the mixed blessing, if you would, of longer lifespans. Because according to the American Medical Association, if you make it to 65 in this country, or actually 62, you have a 50-50 shot of making it to 90. That's almost 30 years of your senior portion of your life, of your retirement portion of your life, if you are fortunate enough to be able to retire in your early 60s. And the unfortunate fact is that only 1% of this great nation has the financial capability of living that 30 years. Think about that. 30 years, that's half the time you've been here. Only about 1% of this country has the financial wherewithal to live that 30 years with a quality of life. So what 62 Who Knew endeavors to do is to bring on experts every Monday here at 5 o'clock at the beautiful studios in Newport Richey, Florida. Every week, national experts, well-known experts, in every separate field of what it's going to take to get you from 62 to 90. And quite frankly, with the medical breakthroughs and scientific advancements in the last 20 years, and what we know is going to happen in the next 20 years, that 90 is going to be 100 much sooner than most people think. All right? So we bring on experts to talk about long-term care insurance, elder law planning, Medicare supplements, Medicare, Medicaid, whether you should have a will or a trust. We bring on people to talk about nutrition. We bring on people to even talk about specialized vacations. We bring on authors about the psychology of retiring. You know, going 20, 30 years was something to do every morning when you get up. Now suddenly there isn't. So many great guests that we've had in the last 2 years, and tonight, or this afternoon, is absolutely no exception. We are bringing back, excuse me, one of our favorite people. This is his second time, Mr. Howard Crooks, the ex-president of the National Elder Law Association of America, a well-known elder law attorney throughout the country, practices in New York and Florida. And we are also bringing on another partner of his company, which is out west, and her name is Ellen Morris. Ellen is running a little late from court today, so she won't be joining us till about a few minutes into the show. But Rob, if you could, let's bring on Howard. How are you, sir?
I am doing extremely well. How are you, Michael?
Welcome, welcome. So Karen's
always good to see you.
Karen's going to be a little late. She's in court.
Ellen is, Ellen. She's finishing up a hearing, and as soon as that hearing winds itself up, she will be joining us.
All righty, fantastic. Now, you already know this. The guests don't. I always get to the studio a half hour early, but there was an accident on the highway, and I ran in at 5 o'clock, which is when the show started. And, of course, I ran in so fast, all our preparation is in the front seat of the car. So pardon me while I go through my emails so I can have everything that you and I prepared for. All right. Let's see here. So how have you been since our last visit?
I've been quite well, thank God. And I'm just pleased to know that you're on the other side of that C word.
Yeah, that was unexpected, and I actually had, quite frankly, a senior processor who was in the hospital for 10 days, intensive care for 6 days, really and truly almost lost her. And she is home now and recuperating, but lots of recuperation in front of her, damage to her lungs. People who just don't take this seriously, I just don't get it, because it just whipped through my company. Another processor had it as well, and it was serious. And their children had it. Everybody had it. So I'm so sorry that I'm having trouble.
Michael, I can help you out if you like?
Yes, please do.
Okay. So, I, as an elder law attorney, I get involved in estate planning, advanced directives, which are power of attorney, healthcare surrogate, living will, probate, which is the administration of your estate when you pass away, wills and trusts. So in addition to that, there's a specialized area of law called special needs planning, which is working with people who have disabilities and their family members. And so one of the things we wanted to talk about today is, what exactly is special needs planning, and what do I, as the special needs planning attorney, help my clients to do? So if you are somebody who is part of a family that has a person who's disabled and has special needs, then there's a lot of different things that you have to be concerned about. Obviously, from a caregiving standpoint, any person who requires ongoing care, there's a whole plan that needs to be put in place for that. But the part where I, as the special needs planning attorney, get involved has to do with like legal financial planning, because people with special needs and ongoing care needs that perhaps can be met through government benefit programs such as SSI or Medicaid or both, they need to meet stringent asset requirements in order to qualify for those government benefits.
Yes.
But they may have assets that put them over the asset limit, which is really only about $2,000. And the question that is posed to me is, can I keep these assets and still qualify for the government benefits?
Exactly.
And the answer is, through special needs planning, yes, you can. And you can do it by setting up what's known as a supplemental or special needs trust, which is a trust that if you place the assets into it, then the government benefits agencies are not permitted to count the assets in the trust. Mm-hmm. And therefore, you can park the assets inside one of these special needs trusts. The assets can be designated for your future use. The money in the trust can be used to supplement whatever the government benefit programs do not pay for, and that can be quite a lot of things.
Absolutely.
And sorry, Michael, are you trying to say something?
No, I say absolutely.
Yeah, and so when you're on government benefits, the void that is left by the program, the government benefit program, can be huge. And so whether it's because you got a personal injury award or you received an inheritance, there may be a variety of reasons why a person who is unable to work and who is disabled may have money of their own. You may even have had the money before you became disabled, and now you'd like to avail yourself of government benefits. So how to do that? So we, as special needs planning attorneys, we counsel our clients on how to best protect those assets while still qualifying for the government benefit programs that can help them out so that they can get the benefit of both. They can have the SSI check, they can have Medicaid paying for whatever Medicaid will pay for in terms of medical expenses, and then whatever the funds are that the disabled person has in their name placed into the supplemental needs trust. Now it's not countable as an asset for Medicaid or SSI purposes, and anytime there's an expenditure that's either not covered at all by SSI or by Medicaid, that money can come from the trust so that the person can continue to receive the benefits, but also enhance the quality of their lives through the use of this money. And it reflects a public policy of giving people who are disabled an instrumentality and a means to still enjoy a quality of life, even though they're very much dependent on government benefits in order to live. So that's, in a nutshell, what special needs planning is all about.
And I did find our research. Yay technology. I have a question for you, because what you're saying right now, it just reinforces how an elder law attorney is so needed, because it's actually affecting my other life as a reverse mortgage person. We're not hesitating, but we had to delay a closing for the nicest people. Nice, beautiful home. This is not needs-based. We are doing a reverse mortgage as part of an overall retirement planning tool. And they have a mentally handicapped daughter who they have done a ladybird deed for. So when in fact they pass on, it automatically goes to her. Unfortunately, part of FHA's rules with the reverse mortgage is, even if you're on the deed, even a ladybird deed, you have to attend the counseling. Well, she's mentally handicapped. She can't attend the counseling. So next, the FHA underwriter came back with and said, well, does Dad have a power of attorney? And we'll just do it that way. Well, Dad doesn't have a power of attorney, which probably if he had you as an attorney, he would have had years ago. We can't create a power of attorney because she's mentally handicapped. Now, we did overcome the problem. We are actually removing her from the deed, closing the mortgage, and then putting her back on. And obviously there's a risk there, but it's the only way to close the mortgage.
I suppose another approach, and one that we often look to in the elder law world, is that if you don't have a suitable power of attorney in place and a person's incapacitated, there's a guardianship system in every state in the country. So that is the alternative that emerges as a potential solution to the problem as well.
Absolutely. So now let's talk about homestead planning, which is, obviously we're in a homestead state. I know you practice in New York. Is New York a homestead state?
No, New York is not, so. And there are many other states that are not, quote unquote, homestead states. So I think for the benefit of our audience today, what is a homestead state? Some states have a term of art called homestead that pertains to your primary residence, right? We can all only have one primary residence. We may, jump around the country or even the world and have multiple residences, but only one of them could be your primary residence. And in a state like Florida, if you declare your home in Florida as your primary residence, it's considered to be homesteaded, and it affords certain protections to the property. For example, it's a protection against judgment creditors. So that means that even if you have a civil judgment against you, you are not going to have to worry about losing your home in order to satisfy that judgment if you live in Florida and have declared your home as homesteaded property. But in New York, which does not have homestead protections, if in fact you owe somebody money and they get a judgment against you, there can be a forced sale of your home. Wow. In order to satisfy that judgment, and then you're kicked out of your home. You'll have to move to a different home, presumably of a lesser value, that you can now afford after satisfying the judgment. So the homestead enjoys some protections, but notwithstanding the extra protections that a homestead state might afford, there's still planning that one needs to think about doing to protect it, notwithstanding the homestead status of the property. For example, if one day you want to qualify for long-term care services and have it paid for by the government program. Are we okay?
Ellen is here.
Okay, great.
Do you want her on screen, Rob? There's super.
There she is.
There's super lawyer. How are you, Ellen?
I am doing great.
I think are we on mute?
No, we heard I'm doing great, but then she went on mute.
Can you hear me?
I can hear you.
Perfect. I'm doing great. I'm sorry that I am late to the party here.
I'm not hearing Ellen.
Oh, you're not hearing Ellen? I am. That's weird.
Okay.
Rob will work on that. All right. Well, thank you, Ellen.
Sorry that I was late. I was in a hearing, and sometimes those
there she
hearings
is.
go over.
Fantastic. Howard was just telling us about the difference between a homestead state and a non-homestead state. I have questions for you. I also want to talk to you about being named a super lawyer. I want to know if underneath your shirt is one of these. You know, did they give you a red cape?
Yeah.
So we'll find out about that. But I'm sorry I interrupted you, Howard. I just wanted to bring her on.
Not at all.
Go
not
about
at all.
it. Yeah.
Great to have Ellen on.
Absolutely.
All right. So you might think that in a homestead state, you don't have to worry about planning to protect the homestead because of all these constitutional and statutory protections that are already there. But in fact, you're trying to qualify for government Medicaid. Even though the home is exempt, there are things that can happen along the way that would frustrate your intent in protecting that homestead. For example, if somebody should go into a skilled nursing facility to receive care, then they're no longer residing in their homestead, and it may come to pass at some point, there may be a decision to sell the property. Well, once you sell the property, it's no longer exempt homesteaded property, it's now cash. Cash, which is fully countable as an asset, which would then disqualify you for Medicaid benefits. That's not good. So there is planning to protect a homestead, and the way we typically go about that is we put the homestead into an irrevocable trust, which you have to do at least 5 years prior to needing the Medicaid benefits. But whether you're in a homestead state or a non-homestead state, placing the home into an irrevocable trust is a very commonly utilized planning tool to be sure that what is for most people their most substantial asset in terms of value is going to be protected and passed on to the next generation.
Right. Which in 9 out of 10 times, obviously it is their largest asset. Sometimes it's their largest liability, but it's most certainly their largest asset. All right. So, Ellen, first talk to us about, before we ask you a question, tell me about the award that you just got. Because anything that starts with the word super, I like it.
So I want to say that Howie is also a super lawyer. I'm not sure if you realize that.
I did not know that, Howard.
He is.
It's true.
So we, super lawyers is a process by which you're nominated from your peers. Other lawyers nominate you. And so we're thrilled that we've been consistently named super lawyers by our peers. Usually that's peers that are practicing in the same area as you and peers that may be practicing in different areas.
That is a good honor. Well, congratulations. How many times do you have to be nominated and win before they give you a red cape?
Well, I think I'm going to order a red cape for both of us. So
I think that's a good idea. I might want to get in on that. Howie, the next time we meet at P.F. Chang's, I'm going to bring you a cape.
Absolutely.
Everybody does know, well, if they don't, they will now, or at least the 50,000 people that are watching this show will know Superman is Jewish. I mean, he was created by two Orthodox Jewish men in the 1940s. And if your parents are Jewish, you're Jewish. So Superman is Jewish.
Superman is Jewish.
Yeah.
Is Mickey Mouse Jewish? I got a Mickey Mouse.
I don't know. Walt Disney wasn't Jewish, was he?
See my Mickey Mouse?
Oh, look at Mickey. Oh, that was my daughter's favorite from the magical, God, I'm going blank, but that was my daughter's favorite. But anyway, we digress. So, Ellen, one of the things that freaked me out when I went into the reverse mortgage business almost 15 years ago, and that is my national niche, is how many times there are actually conflicts in the family with mom and dad or grandma and grandpa. And again, I come from a close family. We have our arguments, but not around, my parents are gone now, but when they were here, not around what was best for them. Everyone agreed. So I know you deal with a lot of this. What would you say are the most common conflicts that you see, in a family when involving planning for the seniors?
Sure. Well, let me start with when the senior is still alive, and then maybe just highlight some of those, and then maybe go to after the senior is deceased.
Okay.
So when the senior is still alive, the most common conflicts we see are, one, in Medicaid or VA benefits planning, when an attorney may not follow the testamentary scheme of the senior and maybe only meet with or take direction from the child who happens to be local. And that child says, oh, I'll handle everything for mom. You can put it all to me. You can transfer everything to me, or you can give the personal services contract to me. We don't do that in our office, both Howie and I. When we do planning, that's the first thing we want to look at is what is the testamentary scheme that was in place. If this person was incapacitated, we insist that that be followed. Obviously, if the person is capacitated, the senior is capacitated, and they decide, that they want to change their testamentary scheme, they have the ability to do that. But if it's coming from an adult child to the exclusion of other adult children, that's one issue that we see.
I can see that.
Yeah, you can understand.
Yes.
So moving forward, I guess the next thing while they're alive would be if one child who has access to their parents' funds does lifetime transfers. Maybe they were put on as a joint account holder for convenience sake. Maybe they're the one with the power of attorney, and all of a sudden they become the beneficiaries on the IRAs, annuities, and other investments, whereas prior to that, it was all three of the senior's children equally. And there are some lifetime transfers, and there are changes to beneficiaries upon death, which we may not find out until after the senior dies. Or there are some ridiculous spending that the senior all of a sudden funds a Corvette or a Rolls Royce for the local child, designer clothing, etc. And their Amex or their Visa or MasterCard bill now becomes triple, quadruple, etc., what it was when the senior was handling their own funds. So you can imagine that makes other children upset when they find out about that.
And do you see this often? I mean, to me, again, and my only reference as a non-legal person is my reverse mortgage world, and I don't run into it too much, but often enough to make me upset. When a senior who's sharp, intelligent, has all their wits about them, is going to do a reverse mortgage in order to keep this beautiful home, not because they can't make the payments, but for cash flow purposes, to help with taxes and insurance, because they love that home and actually have a child. And when I say child, they're usually in their 40s or 50s going on the other end of the phone. But really and truly, I wanted to get that house when you were gone free and clear. If I could just reach through the phone and grab this person by the neck going, wait a minute, what's more important, your inheritance or mom and dad having a quality of life for the next 25 years? It just staggers me that adults could think that way with their parents.
I do unfortunately see it more often than I would like to as well. Thank God I come from a very close family, both my side and my husband's side, and so does Howie. And so we all have experience with close families, but unfortunately we do see it. And I'm not going to point the finger at anyone in particular. I think that sometimes we have entitlement going on. No one has an inheritance until the person dies and we see what there is to inherit. Howie and I tell our clients all the time, go in style, because if you don't, your heirs will.
Yes.
So we tell that to our clients all the time. We want them to spend their money on themselves for their quality of life. But unfortunately, we do see it quite often, yes.
Yeah, and we could have a big show with a big panel that would probably make us enemies on the entitlement generation. We won't even get into that because it's a very sensitive subject for me. Today's young, and not all, I have to say that, of course, not all.
Of course.
But the younger people today, what they feel they're entitled to staggers my mind. When we think about, I'm sure I'm the oldest person on the phone, on the TV show, on the panel. When you think about our parents' world and what they did and what they went through, and to today's children who, God bless them, are intelligent, and thank God we were all brought up to do well and make sure our children have everything they need. But some of them have grown up to not realize how hard we worked to make sure they have the iPad, the iPhone, the iWatch, and everything else that they need to have a life. Great kids, but whoa, if my father was alive, he'd be going, oh my. So let's
to finish the answer to your question, if you want me to just finish briefly.
Yes, please.
The other avenue we see prior to death is guardianship. It's incapacity. When the individuals didn't think ahead, didn't come to Howie and me to get their advanced directive planning done, their durable powers of attorney, their living will, their designation of healthcare surrogate, or go to any other attorney, I should say, and just get these documents done, your revocable trust. Those are the advanced directives that should be in place to avoid a guardianship, which would be both a debilitating and embarrassing incapacity determination and a removal of your constitutional rights, and then also a potential fight as to who has control.
Yeah, now that kind of leads me, I'm going to ask you two questions in a row, and then we'll all be caught up, and I have a couple more questions for both of you. But is what you're talking about, is that what, having these directives in place, that's what protects the seniors or the family members from having that fight? I mean, it's almost like a divorce decree.
It does. Yes,
yeah.
It does. Because that's the document in which you select who you want to be your agent under your durable power of attorney and manage your property, who you want to be your trustee of your trust, who you want to make your health care decisions for you, who you want to implement your living will, who you want to be on your HIPAA release so they can get your medical information and make informed decisions. Yes, those are the documents that would avoid court involvement and a very expensive guardianship court fight.
Yeah, which eats into the assets that, I hate to say, the greedy part of the family was so anxious to get their hands on.
True.
Yeah. It's become a weird world, hasn't it? Howie.
Yes, sir.
All right. Talk to me about maintaining supplemental, Social Security, SSI, or veterans aids. I mean, sometimes people have it, and I have talked to people, again, in my other life, in my reverse mortgage world. The fear of losing it seems to be a cloud, like, over them. Should I do this? What if I get a reverse mortgage? Oh, my God, I'll actually have some money. Am I going to lose everything?
Yeah, it's a big deal, actually. And we're seeing more and more cases come into our office where, although we do help people to apply for benefits to begin with, it could be a situation that somebody's been on SSI or Medicaid for any number of years, and then something happens to cause the issuance of a suspension notice or a reduction in the benefits. And frankly, Michael, it's one of those things that I can't really answer well. Why is it so complicated? These are government benefits, and there's people of limited means, and the rules are so complex that when something like that happens, it puts the fear of God in the person receiving the benefits, and they really do, need, and we're happy to provide the help to help them navigate this really complicated web of rules and regulations that have resulted in the issuance of a suspension or reduction notice. I'll just give you an example. We recently were asked to get involved in a case where a couple moved from Brooklyn, New York to Miami, Florida, and the home that they lived in New York was subsidized housing where they were able to get lower market rent. And they didn't want to give that up. They wanted to give it to their grandson, who is now going to be living in New York. But the problem was, according to the terms of the rental agreement, they weren't able to do that until September of this year. And in conjunction with the subsidized housing piece, there was an equity value attached to the apartment. And it was enough of an equity value that would put both parties, the husband and the wife, over-resourced, too much assets for SSI benefits, and they got a notice saying that, because what happens is the Social Security Administration calls these people up and over the phone asks them questions, and innocently they disclose information that they don't realize is going to cause them to run afoul of the rules, and they don't know how to navigate it. So that may come into our office, and what they were not aware of is that because they were not able to access their equity value until down the road, we were able to take the position that it's actually an illiquid resource, because there's nothing that they could have done to actually liquidate that equity value now. And when they do liquidate it, we were able to counsel them to funnel that money into something called the prepaid funeral contract, which is an exempt asset for SSI purposes. And through the work that we did and the disclosures that we made to the Social Security Administration and the phone conferences that we had with the representative from Social Security, we were able to reinstate their SSI benefits. And
Wow.
there's a huge win. And it's just a matter of like anything else, like, I don't know about you, Michael, but I wouldn't pretend to do anything having to do with my car, fix my house, anything like that. I got to hire a guy. Yeah. Right. Well, so when it comes to these, kinds of issues, it's really helpful to have somebody that knows the ropes and can help you navigate these rules and regulations.
Well, what an understatement, though, that getting them back their SSI or getting it back up, to full capacity is a win. I mean, it's a lifesaver. It's a life changer.
It's an understatement. I mean, this is an SSI check that they live on month to month, and any interruption of benefits, if they're fortunate enough to have family member that can help them out to ride out the storm, then great. But there are some people who don't have that luxury, and it's a big deal.
Oh, yeah, and even worse, they have people that think they know how to negotiate it, but really have no idea. That seems to be I have people all the time that, my brother-in-law told me that if I get a reverse mortgage, you guys take my house at a certain age. Nothing could be further from the truth. Even before the new rules happened, that was never true. These people that think they know what they're doing, and everybody thinks they know what a lawyer knows, and they just don't. You don't learn that stuff, unless you go to law school. So, Ellen, here's a hard one. You explained a lot of what you can do, when there's conflicts, and you can still talk to the live person and say, what's your true feelings? What do you want? What if there's a conflict going on after the person is deceased? I mean, who's right, who's wrong? One guy's going, it's the Smothers Brothers syndrome. I was always mom's favorite. She wanted me to have that Corvette. And the other brother goes, no, no, no. And you have no one to talk to now. True. That's rough.
So it is, and that's the litigation. That's like sort of the second part of what we discussed of litigation after death, right? So that's the litigation that involves state, trust, or fiduciary litigation, in which we have to subpoena all the financial records, we have to take depositions, we have to file a lawsuit, and it's a regular lawsuit, and so the subpoenas and the depositions are part of discovery of the lawsuit. And we have to show what the intent of the testator was. We can do that by looking at the documents, the will, the trust, the power of attorney. And that's why when we draft our documents, they're not just blanket documents. We try and make them as custom and as detailed as possible to enable someone to glean what the intent was even after the individual's death.
Mm-hmm. It's got to be rough to put together the puzzle, though, without the original person going, but this is what I wanted.
So it helps for sure to have that, black and white. I don't want my kids to be a spendthrift, or this is how I want everything to be distributed, and it definitely helps. But in today's world, you can find everything out.
Yeah.
Through discovery, through subpoenas, through your computer behind the scene records, your metadata. and all of that.
And
know,
you
can
subpoena
really,
all of these things.
yes,
Family member versus family member.
if it has to be, yes.
It's just,
It's a
you
shame,
see
but
that
it's
kind of, I'm sorry, go ahead.
I was going to say it's a shame that families, are splintered that way, but it's just a fact of life. I mean, on the one hand, you don't like to see the litigation or the fighting or the splintering of the family and maybe complete, disinheritance of each other and disavowalment of each other on the one hand. But on the other hand, if you're the adult child who was left out, you can understand why you might say, well, why should my brother or sister, just because maybe they had the opportunity, why should they get everything and I get nothing?
Which is a logical question. Because mom never really liked you. No, that's not a good answer. That's just
Well,
not nice.
if that's true, then mom needs to be specific about that in her document.
Yeah, we've actually had a couple of things like that. Only a couple in the last 15 years where we have had parents call us, our clients call us, and say, "Look, I know you've heard from my son or my daughter telling you that we're questioning this decision." And we just have to tell you, Michael, we love our son dearly. He's in his mid-40s. He's been an alcoholic his whole life. He's never supported himself. He has what he says, just please ignore. And, be polite to him, please. But, yes, he wants this house free and clear. But we want to travel the world. And we're getting a reverse mortgage. So it's just sad. Now, Howie, I know maybe part of this is for you and part maybe for Ellen. You would laugh as attorneys how many times as a mortgage person, the client says, "Oh, my house is in a trust." I go, "That's okay. Fannie Mae and Freddie Mac and FHA, they don't have a problem with that. They do have a problem with some irrevocable trusts, which might be a topic for a future show, but on a whole, not usually." And I'll say, please send us the trust, because the title companies and the lender's legal department has to look at it. And they send us the trust. And we open it, on the email, and there's nothing in it. I mean, it's just blank. So we call back, and it's unbelievable how many times this happens. And I go, I thought you said the house was in the trust. They go, well, what do you mean? I go, well, you sent the trust. Maybe you accidentally sent me a blank or a sample. There's nothing in it. What do you mean there's nothing in it? I went online. I paid $90 for a trust. I go, but what did you put in the trust? They go, what do you mean? And I mean, these are not dumb people. These are intelligent people on very nice retirements. They go, we have to, what? I just saw an ad that said, if you want to trust and you want to save taxes, click here. It's $92 and there's nothing in it. So it's just staggering, how your services are needed, not just to me by the wealthy, but by, by the everyday, I won't say lower income, but at least the everyday average to upper middle income person. If they're not consulting with professionals like you, it's just a crazy thing, which brings us again to, maybe this is more in Howie's line, I'm not sure. Should parents be gifting things to their children and grandchildren? Should they be setting up trusts for the children or grandchildren? Or, how do you decide that? Is that up to their assets, their net worth? How would you decide what people should start doing that actually have, a portfolio and want to pass it on with as little tax liability as possible?
How, you want to take that first?
Just address the talking about. Sorry? Can I just address the first part of what you were saying, Michael?
Oh, I'm sorry. Trusts versus gifts versus the will. How do you define? And I'm sure I'm sure you have to look at the whole package. Which is the best to pass on assets with the least tax liability? Should it be a trust? Should it be a sub-trust, a family trust? Should it be just a plain will? You don't have enough money for a trust. Should you start gifting things?
So, Michael, can I just address the first part of what you were
Absolutely.
talking about? So when it comes to doing a trust, what people don't realize, and maybe it goes to the mantra, you get what you pay for. But when you do a trust, some people think mistakenly that the lawyer took care of everything, or I did the trust, so now I'm done. But the most important thing and takeaway from what you were saying is you have to fund, it's called funding the trust. You have to title assets in the name of the trust in order for that trust to be effective. So what that means is you could spend days, weeks, months on your trust, drafting it to make sure it says what you want it to say. And if you forget one thing at the end, one very small but very, very important thing, you may have exactly what you just trust.
I'm sorry, Howie, you froze up there a little.
He's freezing, so I can finish if you don't. If you
Yeah,
want me
please
to.
do. Howie, if you
So-
can hear me, you're frozen for some reason.
If you're not fund,
I don't know. He's freezing. So yeah. So he was just basically. We could both answer that question, but basically, it is if you don't put your assets under the trust, then the document is worthless.
Yeah.
And it's just whatever you paid the attorney, or whatever it costs. For the paper.
There's a
that it's
strange
keeping
man
on.
behind you. Do I need to call 911?
Sorry, that was my husband. So what I wanted to give your viewers and your audience a good analogy about a trust, because even more so is, what is a trust? We get those questions all the time.
Could you turn
And
your
I think-
volume up just a little, Ellen, if you have one? We hear you, but it's very low.
Sure. How about now? Is this
Much better. Thank you.
Okay. It's just like, what is a trust, and why is it just worth only the paper that it's on, right? A good analogy is to think of a trust as the trust is the umbrella, the canopy, right? The actual document is the canopy of an umbrella. And the only way your umbrella stays open to protect you from the rain is if the spokes of your umbrella are not broken and they can stand straight and hold your umbrella up. So the trustee is either the person themselves or the successor trustee is the one who holds the umbrella. And everywhere the trustee walks, the umbrella, as long as the spokes are in, stay up. And the spokes are the assets that are in the trust. The spokes are the assets. If there are no assets, then there are no spokes, and there's only a collapsing umbrella. It doesn't protect you. So you've got to title your bank accounts, your investment accounts, your home, your CD, your brokerage accounts into the name of your trust, and then it becomes a spoke of the trust, and it's protected under the trust umbrella. Some assets that you cannot put in the trust are your IRAs. Those are individual retirement accounts. Those always stay in the individual's name. Your 401k, which is the same in the individual's name. And usually personal property, you don't put that in the trust, although if you have a lot of personal property and you think there may be an issue as to its distribution upon your death, you can have an assignment prepared. We prepare an assignment where the individual is assigning their personal property to the trust, and this way the trustee then has authority over it. So an assignment is another spoke. Is that a good analogy?
I was just going to say, what a fantastic analogy. Rob, are we trying to get Howie back? He's back and he left. He went to get his umbrella. Ellen, that is such an, really and truly, that is an incredible analogy. I have to ask, have you ever used that in an illustration, an umbrella, and named the spoke?
I use it all the time.
No?
I use it all the time.
Oh, you do? Yeah, that is, I think that's incredible. Because it just is. Howie, can we hear you? No. That's strange. Can't hear you. He's becoming mobile. Check your volume.
He's trying to walk around his. We had the air conditioning was broken in our office building today.
Oh my God!
You can imagine how it was just a steamy sauna in there. So he and I are both working remotely.
I think I'm back.
You are. What is it? Just a bad signal?
I must be a problem with the internet in the house. I apologize for that.
Oh, don't be sad. It happens. Technology.
Yep.
But I
So
do love that.
I think I heard
I love your
Ellen
ceiling.
answer
Though.
the question about the revocable trust and funding it.
Yes.
But prior to that, you had asked a question about planning for your kids and whether it's better to do outright gifts or set up sub-trusts.
Absolutely.
So let me try to tackle that one.
All right.
So when you give assets upon your death to your kids, you have to decide whether you want them to get those assets directly upon your death and without any strings attached, or whether you want to create what are called sub-trusts, ongoing trusts, so that there are parameters and boundaries that you can place on the distribution of the assets. And you can do things like, I'm going to give my assets to my child, but at the following ages, like 25, 30, 35, 40. Everybody has different ways of doing that. Or you can say that I want to make a distribution of a stated dollar amount every year. So like for every year for the next 10 years, they're going to get $20,000. There's different strings that you can put on that. And why would you do that? Well, you may have a child who's not very good with finances, and you're worried that the entire inheritance is going to be spent very quickly after your death, and that's not to your liking. There may be problems with a spouse of one of your kids, and you might want to put strings for that reason. So you really have to just know your own children and your own personal wishes, which will dictate whether or not you should give outright distributions at your death or whether you should create sub-trusts.
All right. Now, I want to ask, I don't know which one would want to answer this, or please both. I'd love both your opinions. We had a guest several weeks ago that is the head of an association that deals with silver/gray divorces. Divorce rate for people in their 60s is skyrocketing, 60s and 70s, now that we're living to our 90s. And in many cases, that is quite possibly a second marriage itself. So there might be his children, her children from a past marriage, which are obviously adults, their children that they had together, which are adults. That has got to make estate planning staggeringly harder. Well, this is going to them, but I had this before I married you, and now they're getting divorced later in life, so I'm assuming things aren't the friendliest. Have you ever run into that gray divorce where this is literally the second divorce, and the heirs are not all from the same parents?
So we do get consulted about the role that divorce could play in estate and long-term care planning. I have to say that we haven't had to rely on it as a resolution of the planning that the client has wanted to do. It's an extreme example of what people can do and think about doing, but there's usually enough alternatives to avoid that being the end result. I'll tell you what I have seen more frequently, which is people who meet older in life and approach us and say, should I get married?
I've read about this. Yes, please go ahead with that.
Is a very, the answer is, nobody's going to accuse me of being a matchmaker in that circumstance, because when you marry later in life, what you don't realize oftentimes is that you now become personally responsible for the long-term care costs of your spouse. Whereas had you decided not to marry, then especially this is true when you have one spouse that has the bulk of the assets and the wealth, and the other spouse who has not very much to bring to the would-be marriage, then it's not a really good idea, because the person with all the assets is now on the hook if the other spouse gets ill.
That makes a lot of sense. And again, we run into that in my industry as well. When, I just love people in their 60s and 70s, and you go to their beautiful home, or they come in, and just wonderful people, and you make the false assumption that they're married, and they go, "Oh no, we've been together for 6 years. We're not married." I go, "Really? 72 and 74 years old, and you're shacking up." I think that's incredible. But whether it be for Social Security. You know, I think we are going to see a trend of, or maybe we're already seeing it. I don't know what you think, of seniors living with each other for financial purposes rather than getting married.
Yeah, I think so. I think so. So it just depends on the circumstances, Mike. If you're already married, what can we do to try to help you out? And we certainly have in the estate planning side of things some difficulty. I've got a client right now who wants to provide for his wife, but he doesn't want to provide for his wife's sons. And it raises some pretty thorny issues to make sure that somehow or other he can provide for his wife, but not let the sons get control over the money if he dies first, and then pass the remaining money that's not used while his wife is alive after he dies to go to his own two daughters. So the very thorny issues.
Very thorny issues. Ellen, have you run into the 2- and 3-time divorce that there's children from his, hers, and mine involved?
Absolutely. And one of the issues that we see in the 2- and 3 times divorce has to do with the elective share. If they do end up getting married, contrary to any recommendation that they may get to just live together. So the elective share is something in Florida, it's a concept in Florida in which a spouse is entitled to a 1/3 share of their spouse's estate, barring any other planning, let's just say. So, of course, if there's a prenuptial agreement before they get married or a postnuptial agreement after they get married, there may be waivers of that right to an elective share, meaning both spouses, husband and wife, may say, I waive any right to my husband's share upon his death. I waive any right to my wife's share upon her death. Everything is separate. We're not combining, I waive everything that I might be entitled to by virtue of Florida law upon my spouse's death. So maybe you have that. But if you don't, you may have an elective share issue. And if you don't plan properly for that elective share, either putting the elective share in a trust or under your will, or consciously knowing that if your spouse seeks the elective share, they're going to get that share outright. And so when that spouse dies, if there's anything left of that elective share, it won't go to, the person's kids from prior marriage.
The wrong child.
Or kids from prior marriage. I don't know if maybe it's the right child. I don't know. But so there's a lot of planning to avoid litigation surrounding this elective share. And in Florida, you can be married for a day. You can be married for a week. You can be married for a month. And your spouse dies unexpectedly, and you intended to keep all your assets separately, but that intent is irrelevant under Florida law unless you did the planning.
Wow.
And your spouse will be entitled to that 1/3 share.
I can see upset children at that.
Exactly.
I'm going to ask an unusual question. There's only a few minutes left. I can't believe an hour went by this quick because I still have more questions. First, before I ask this question, would you please give us your website? Somebody?
Sure. It's Elder Law. Go ahead, Hal.
Sorry. www.elderlawassociates, all spelled out, ELDERLEW, the word associates.com. And there's a picture of it.
Yep. Is that you confidently walking through the hallway?
It's got a lot of information on it, Michael.
Yes, I've been to it. It's an excellent site. For those of you that didn't catch it, you can always go to 62whoknew.com. Just throw in, hey, Mike, I need to talk to Howard or Ellen. Please put me in touch. And, of course, we'd be glad to do that at www.62whoknew.com. And then something that we spoke about, Howie, the first time you were on, and then I went down the COVID corridor, is possibly putting a link of your website on our website. So it's always there.
Terrific.
Yeah, I would love to do that. I mean, again, in my mortgage life, whether it be reverse or a regular mortgage, what I see, coming through is, oh, I didn't know we could do that. Oh my God, we should have done that. And they're not little things. They're life-changing things that if they had spoke to professionals like yourself, things would be much better. With a little less than 2 minutes to go, and I need 10 seconds to say goodbye, I ran into something a couple of days ago, and I don't know if you have yet when it comes to assets. We had somebody purchasing a house, not a senior citizen, and their down payment, which as a mortgage person, of course, I have to verify. So when my processors verified it, they had sold approximately $50,000 in cryptocurrency for $50,000 and put it in the bank. And I had three of the largest lending institutions in the country go, we will not accept that $50,000. What do you mean? It's money. Crypto is not a proper asset. It is too volatile to keep a value on. Again, what's the difference? I showed you an account that said it was worth $50,000. He hit the sell button. He got $50,000. And I had to actually find another national investor, also very large, who is accepting cryptocurrency. And I probably took too long to ask the question because there's only 50 seconds left. But are you seeing financial statements with crypto being a large part of it? Just I need a quick answer.
Yeah, not really, Michael. I think the senior population tends to be,
a little more conservative.
Practices the KISS principle, keeps it very simple. Their portfolios aren't necessarily, in cryptocurrency.
Yeah, that makes sense. Ellen, have you seen anything?
Not as much. I think we're going to see more of it, but not as much. Remember, we're not dealing with the high net worth individuals. We're not dealing with, $20 million net worth of assets where they're really diversifying in those types of assets.
All right, we got 6 seconds left. Thank you both so much. I love having super lawyers on, and we're going to get your website up on the site.